device?
I have not called law
Well,
enforcement.
who has?
We have the people at our headquarters,
So
our main
somebody with
office.
your company did. You're here.
They could have, yes.
You're here speaking on behalf of Nationwide today, so I'm asking you about your records. You talked about your records. Has someone at Nationwide called law enforcement to check on this device before?
Yes.
Okay, and what did they tell you?
They just need to check in to make sure the device is on. They said it's on and it's charging.
Okay, that it was on and it's charging. And that's because you didn't have information that it was charging, correct? They were called for a reason.
Oh, I can't speak to that. Usually that is what they do, yes. And it also has to do with if the client answered the phone. Usually we would call them first before.
Good morning.
Good morning.
Please state and spell your name.
My name is Destiny Harlan, DESTINIHARLAN,
Where are you employed?
Nationwide Electronic Monitoring.
So that was really fast. Nationwide Electronic Monitoring?
Yes, sorry.
What do you do what does Nationwide Electronic Monitoring do?
We're a GPS company. We monitor people through GPS devices and other electronic monitoring services as well.
Okay. Do you know of a Christina Cervantes and if she's on your caseload?
Yes, she is.
Have you reviewed her file prior to today?
Yes.
Has she had any issues with the charging or battery with her or anything to do with her GPS device?
Yes.
What are the issues she's been having?
Specifically, issues with her battery, as far as it going dead or almost going dead, and then due to her location, she has communication issues.
Okay, let's talk about that with the communication. What do you mean by that? She has communication issues.
So sometimes, depending on the location of houses, even what the house is built of, there could be issues where we don't always get a signal from the device.
Okay.
And she just needs to step outside and move around just so we can get a signal on her.
And do you know if that was relayed to her last week through her attorney?
Well, through her, I've not talked to her attorney.
Okay. Has she had any issues since last week? In the last 5 days, has she had any issues with her device?
Yes.
What are those issues?
Both the communication and the battery.
How many times do you think there's been a battery alert since she's been on?
Since she's been on, it's been quite a few.
What is quite a few? 5, 10, 100, 200?
I'm going to say at least 50.
At least 50 since being on bond?
Yes.
Okay. And since last week, was she notified to your knowledge about any kind of needing to step outside?
Yes.
And we continue to see the same issues?
Yes.
Okay. Is there anything else you think the court needs to know?
With the location thing, sometimes that's really not her fault. It's all based on where the house is and what the house is built of. But the battery thing, she has been notified of that. So
And she has not been following that based on this?
yeah, based on.
Deleting your own.
Has she been following the orders after you notified her?
After we notified her of charging, she says she's on the charger.
Okay, has it been having issues since then?
Yes, we still have issues.
Like what?
Again, just keeping it charged. We have times where she just doesn't charge it enough. You should charge it for at least 2 hours a day, so that's an hour in the morning, an hour at night.
How long has she been charging it in the last few days?
It's different times each time.
Do you have an example?
I do.
What are they?
These are our charge. We have charging reports. It goes through, and it shows how the minimum and maximum time she's charged in a single day. So sometimes.
In the last 5 days, what do they look like?
Okay, I do not have the last 5 days. The last one, oh, actually I do. So the 17th, it looks like her average charging time was 14 minutes.
14 minutes. How long is it supposed to be?
And it's supposed to be 2 hours a day.
Okay. Anything else?
Yeah, I can go back as far, that's what it's like a few times throughout the month.
Okay. That's all that I have. Thank you for your time.
Mr. Potter?
Yes, sir.
I'm sorry. There have been times when my client has attempted to charge her device, but you're not showing it on your end that it's charging. Is that right?
Yes, and that's when we have her step outside.
As a fact, you FaceTimed her on at least one occasion and watched her charge it, but on your end, on your electronic end, it's showing that it's not charging at all, but you're watching it charge.
Yes, again, that's the communication thing.
And communication, when you say communication, Not her lack of communication, but the device is not
Communication.
communicating to the headquarters.
Yes.
Okay? She lives at 919 Andrea Avenue in Bon Aqua. Is that
Yes.
right? Okay, and so there are places where the devices themselves don't send clear signals to the headquarters, correct?
Yes, well, to the
I'm
satellites.
calling it the headquarters, I don't know what you call it.
Yeah,
But you have to get a signal back from the GPS device to where you are. Is that
well,
right?
it needs to be connected to the satellites because
Okay.
just like a cell phone.
And sometimes these devices, depending on where they're at on people, don't make clear connections to the cell phone, to the satellite, right?
Well, it depends on their location as far as if they're in the, a rural area. So, yeah,
May not work as well as if they're in an urban area.
yes.
If she's in the city of Dixon, you're probably getting a clear signal, right?
Well, as soon as she steps outside, really, if we can get, if she steps outside, we usually tell people 10 to 15 minutes, we're able to get location on her, well, communication again.
In fact, she contacted you last week about getting a new device or a new battery, and you told her, charge it and let me see what it does, and you watched it, correct?
Not me specifically last week. We've had that discussion though, yes.
And you said, rather than get a new battery, might be a good idea to just go outside and walk around a few times.
That was not me specifically, so I can't say
But
yes
it's your
or no.
company, correct?
Yes,
I mean, the whole point was to try and get a signal going,
yes,
because there wasn't a signal.
yes.
She has called called your office, I don't know if it's you or someone else, but she has called repeatedly and complained about the fact that it's not charging. Is that right?
Yes,
In fact, she had to go one time and get a new battery for the device, or a new charging machine for the device. Isn't that right?
she got a new charger, yes.
A new charger, because she was having that very problem, correct?
Yes, but we just switched out the chargers because we did not think it was issue with the device because she doesn't charge it consistently. So that's also the issue. When you're not,
Do you have any evidence that you can offer this court about her being any place that she wasn't supposed to be?
she doesn't have any places that she's not supposed to go. We were not given exclusion zones for her.
She doesn't have any geographic restrictions?
Yes.
Okay. You haven't seen any report or anything that raises your suspicion about where she's at enough to make that report, have you?
No, because again, she was not given any exclusion zones. So,
How often does someone need to charge one of these batteries on a daily basis?
it should be a minimum of 2 hours a day. So it's an hour in the morning, an hour at night. That's
Tell me how that works logistically. I mean, they're wearing it. So what, do they take it off to charge it? I don't even know. Educate me.
No, you do not take it off the charger. It stays on your body and you just sit down for an hour and charge the device. Hook it up to the wall and then hook it up to your leg. It's just a regular power cord.
Power cord that plugs into the device on your leg.
Yes.
Okay. And you say that has to be done 2 hours a day. But you know that Ms. Cervantes has been charging her device. There's no doubt about that, right?
Inconsistently, yes.
No, you think that it's her, or is it the device?
It's her because I can tell from the charging reports
Okay. What can you tell from the charging reports?
that she's only charging him for not, like specifically on the 17th, she had only charged it for a total of, what was it, 22 minutes that day? And it's supposed to be 2 hours.
I thought you just got through testifying under oath that there are occasions, Ms. Harlan, when the device is charging, but at your location, you're showing that it's not charging.
Yes, but that's not all the time.
Okay.
And that,
But it's
that's a
sometimes.
communication thing. We're going to get the reports regardless because as soon as she's back in communication, we receive all the data that was already recorded with the device.
But you can't tell us from looking at your charging report how much of that is her and how much of that is the device itself, can you?
Yes, we can because again, it only records if she's charging the device. So as soon as she hooks that charger to the device, we are given that data. Let's say she's out of communication. As soon as she's back in communication, we get that data. So it's fairly accurate. Even if we don't see it right at that moment, we're going to see it eventually.
So if you're out of communication, she could be charging the device and you're still showing that she hasn't charged the device, but only when she gets back in communication can you see that the device was charged.
Yes.
Is that right?
Yes.
But you don't have any way of knowing once you see that the device was charged, how long it's been since it was charged, right?
No, as soon as she's back in communication, I can see how long she's charged it when she put it on the charger.
Okay. You have your reports with you?
Yes.
Can I see them?
Uh-huh. Let me put them back in order. This is just the charging report.
Did you prepare these reports?
Yes, I just printed them from our database.
How does your database work?
We have, well, it's called ScramNet. It records all the all the information from the device. We don't put anything in. It just gives us the information and we print it out.
Do you know how the database works?
I do not.
You can't give us any information about how that database works. You just get the information from it, right?
Yes, uh-huh,
And that's what you're relying on.
yes.
But you've actually had a Facebook time with my client in the last week
Yes.
wherein she's charging it and you're not showing that it's charging in your database.
Yes, and that's until she stepped outside, which we also did during that phone call.
What are you doing to correct those problems that you're having at your company? What's Nationwide doing about, there's times when these people are on GPS monitoring devices and they're in locations where you don't get any signal at all. What are you doing about that?
That's when we ask clients to step out for that 10 and 15 minutes because just like a cell phone, sometimes it loses service because it's relying on the satellite. But I'm only the program manager, so I can't speak to what's going on behind the scenes as far as this stuff goes.
Have you been to my client's house?
I have not.
Has she asked you to let her replace the battery on the device?
She had, oh, well, we can't replace the battery like I've told her before. We would have to replace the whole device.
Okay. Was she asked to do that?
She has.
Okay. Have you done that?
No,
Why not?
because again, we didn't think it's a device problem, it's a charging problem.
But what
She's
if you're
not
wrong?
charging- Because it's been charging and we haven't had any issues until she's just not charging the device. We have days, like the last 2 days, I'm gonna say the last day, I haven't had to call her about charging the device. It's just been charging.
So you're not trying to present to the court these devices are foolproof, are you? They actually do fail, correct?
I'm not here to testify to that at all.
You just don't know.
Yeah, I guess.
No further.
Ma'am, let me ask a couple of questions to educate myself as well. You have reports that the devices, that there's a charging issue,
Yes, sir.
right? And that means that according to your information, she is not charging it for the sufficient period of time.
Yes, sir.
All right, has the device ever stopped working because the battery went dead?
As soon as the battery goes dead completely, we lose communication with the device.
So I guess that's what I'm trying to find out. Other than her charging it for 22 minutes as opposed to 2 hours, is there information in your records that indicate that there was a failure of the device, or in other words, that it went dead?
Well, yeah, there's a couple times her battery has went dead completely.
And that would be because it was not sufficiently charged?
Yes.
And again, is that relating to your records that you have that show when she's charging it and when she's not?
Yeah, so, oh, sorry.
I'm sorry. Mr. Potter's made good points that I want to explore a little bit. One of them is, if there's a failure of communication, that means your device is in her home or wherever she is not communicating with your base where where you're receiving the information. Kind of like, a cell phone that's out of service or whatever but so you would not have any information, if I'm understanding correctly, about what's going on with that device while you're out of communication.
Yes, we wouldn't get anything until she was back in communication.
When communication is reestablished, and can you tell me what would cause a lack of communication, just the service?
Just the service.
Okay. When communication is reestablished, what then do you learn about the device that was taking place during the time it was out of
Yes,
communication?
we will get the data that took place when the device was not in communication. So we can see the battery, the last known location before the device completely went off.
So it would have the last known location. Would it also show you when it was charged
Yes,
and
sir.
how long it was charged?
Yes.
All right. So could the communication issue that's been raised be responsible for showing that she's not charging it when she is?
No, we can still see when she's charging it. Sometimes she will be charging it when it's not out of communication. And we can see, she's not charging it when it's not out of communication. So it could be, the device could be working properly and she still not have it charged. The device is not always out of communication.
Okay, thank you. Yes, you may.
To your knowledge, is information stored on the device like a cell phone would store information?
Yes.
So let's say I have a device on, I put it on, I charge it for 2 hours, then I step outside for the 10-minute period. Would it show I charged it for 2 hours?
Yes.
If I charged it for 5 minutes, would it show that?
Yes.
So it's not the issue of the time.
Object to the lead.
Is it an issue of whether it is an issue of whether the information's correct or just an issue of getting it to you?
More of a information getting it to me, especially again, if it's out of communication.
And you notified her about going outside,
Yes, we had that conversation during that FaceTime call.
and you continue to get violations.
Yes.
Nothing further.
Mr. Potter, any questions?
Check on the device.
I have not called law
Well,
enforcement.
who has?
We have the people at our headquarters,
So
our main
somebody with your
office.
company did. You're here.
They could have, yes.
You're here speaking on behalf of Nationwide today, so I'm asking you about your records. You talked about your records. Has someone at Nationwide called law enforcement to check on this device before?
Yes.
Okay, and what did they tell you?
They just need to check in to make sure the device is on. They said it's on and it's charging.
Okay, that it was on and it's charging. And that's because you didn't have information that it was charging, correct? They were
I
called
can't
for a
speak-
reason.
Oh, I can't speak to that. Usually that is what they do, yes. And it also has to do with if the client answered the phone. Usually we would call them first before.
Tina D. Cervantes, and it's state's motion to revoke bond. The state ready?
State's ready, Your Honor.
Defense ready?
Ready, Judge. Can I bring the defendant around?
You may. All right. Mr. Stevens, you may call your first, you wish to make an opening statement or just call your witness?
I will, just for a brief general overview, and Mr. Potter, would you like the rule? Okay.
The rule has been requested, so any witness who's going to be, any person who's going to be a witness in this matter needs to go outside of the courtroom and remain outside of the courtroom until you yourself are called to testify. You are not to discuss the testimony of any other witness with anyone prior to testifying yourself.
Your Honor, and if I may, Aiden Hollis is the state's affiant, so I ask that he remain. We're going to be calling Miss Sarah Dwyer first. She can remain in the court. Her husband, Daryl, I subpoenaed him, but I'm not going to call him. So I'd ask that he be able to remain in the courtroom as well. But that would need Ms. Stedman, Ms. Whitney, and I believe the tracking company representative is already outside.
All right. Well, you want to respond to that, Mr. Stevens?
The state is going to show a history with Ms. Cervantes that's absolutely relevant to the current matter with her contested drug screen. And we need to show the concern of the safety to the community with Ms. Cervantes. And that absolutely brings up it's not going to be a trial by any means, but a factual basis to justify the state's concern of her continuing to be out on bond while using illegal substances and arguably not using her tracking device appropriately.
Not a sentencing hearing, so we're not here today to talk about what type of sentence ought to be imposed. It's really a very narrow thing. She had bond restrictions. Did she violate those bond restrictions or not? The state is not asking for an increase of the bond restrictions. I've not seen any kind of motion to that regard. I've not seen the state ask that the bond restrictions be changed in any way. She has pretrial restrictions. Either she violated them or she did not.
Again, Your Honor. Go
Let
ahead,
me
sir.
just deal with this. The state's motion to revoke bond is the state's motion. They have the right to put on the proof that they deem to be appropriate. The defense obviously has a right to object to relevance, but until we get to a witness that, and I hear something regarding that, I think it would be premature for me to rule simply that the state cannot present certain proof because of the fact that it's their motion. I'm going to allow them. There are many factors that go into a bond, and the motion to revoke bond that comes under a statute is one that I think the state has some leeway regarding the evidence. So, Mr. Potter, you have the right to renew your motion regarding relevance, but at this point, I'm overruling any motion that you've made. All right.
State calls Sarah Dwyer, Your Honor.
We swear affirm the testimony given
So, Your Honor, for the record, I'm going to object to Ms. Dwyer's testimony. She is, I believe, the mother of the victim in this case. So she doesn't have any knowledge that she can offer this court about whether or not my client violated pretrial bond conditions. She could probably tell this court how injured her child is and how hurt he is and why she wishes that Your Honor would put my client in jail, but none of that is relevant to this hearing today, respectfully.
Overrule the objection.
Good morning, ma'am.
Good morning.
Please state and spell your name.
Sarah Elizabeth Dwyer, SarahElizabethdWyer.
Okay. Do you know an Aiden Dwyer?
I do.
How do you know him?
He's my son.
Did something happen to Aiden on January the 11th, 2026?
It did.
Was he involved in a car accident?
Yes, sir.
Before this accident, and as you've heard, I'm sure, we're not here at trial, so just generally.
Right.
What kind of person was Aiden? What was he doing?
Very outgoing 19-year-old. He was about to start his sophomore year at MTSU for animation. He loved going to the gym. He loves his family, his friends. Just a sweet, fun-loving guy. Loved to work out. Loved to hang out with his family.
Can you tell me about what happened to him after the car wreck? What happened?
I'm not sure where to begin.
What has changed?
A lot has changed.
What are his injuries?
It's just, he has a brain injury, number one. It's called DAI, diffuse axonal injury. Sheared the axons from his brain. He still has some cognitive issues, thinking, speaking.
Was he hospitalized?
Yes.
For how long?
He was in the ICU for 16 days. He has other injuries as well, but yes, he was in the ICU for 16 days. He went on to select specialty care in Nashville. And then after that, he went to Westmead Place, on to Shirley Run in Chicago, and he's now at QLI.
Okay. And do you have concerns when you go past the scene of this accident?
I have to drive by there every single day to and from work.
Okay.
I have flashbacks. Just imagine, what that looked like.
If the driver involved in this was under the influence of an impairing substance, would you be concerned with her continuing to use impairing substances while on bond?
Yes, I worry about that every single day.
That's all that I have. Thank you.
Paul, you have questions?
All right, first of all, I'm very sorry about your son. Do you have any knowledge that you can offer this court today about whether or not my client has driven a vehicle since the date of that accident?
I have no idea.
Do you have any information that you can offer this court about whether or not my client has adequately maintained her GPS monitoring device since the date of that accident?
I have no way of knowing about that.
Do you have any information that you can offer this court about whether or not my client has failed any drug screens since the date of this accident?
I don't know.
Do you have any information that you can offer this court about whether or not my client has failed to meet attend any pretrial appointments since the date of this accident?
I'm not sure.
Thank you.
Thank you, ma'am. You may step down. You can
Thank
have
you.
a seat in. Thank you. You may step down. State has rested their proof, Mr. Potter.
Of responding to this motion.
Solemnly swear or affirm that the testimony
Cindy, do you have a copy? Does the witness still have a copy of those text messages? They're still up there. Okay. All right, I'll ask you about those in a minute. All right. Tell the court who you are.
Christina Cervantes.
Okay. Ms. Cervantes, you understand why we're here today, that the state's filed a motion to revoke your pretrial bond release,
Yes, sir.
and they're alleging that you have violated that? You
Yes.
understand that?
Yes, sir.
So I'm going to get right to the point and ask you some questions. Okay? Have you used methamphetamine at all since you were placed on bond?
No, sir.
Okay. Have you used any type of illegal drug since you were placed on bond?
No, sir.
Are you willing to take a drug screen today?
Yes, sir.
After you learned that this motion to revoke bond was filed, did you get my advice to go take a hair follicle test?
Yes, sir.
Did you go that day to get one done?
I did.
And what day was that?
It was the last Thursday.
Where did you do it?
Workforce Essentials in Waverly, Tennessee.
Took you there?
My mother.
Because one of your pretrial conditions is you can't drive, is that right?
Correct.
Have you driven a vehicle at all since you were placed on bond?
No, sir.
Okay. And when you got when you went to get the drug screen at Workforce Essentials, did you cooperate with them in every way?
I did.
Did you ask them to do a full panel of testing for you?
Yes, sir.
And that was what date last week?
Thursday of last week.
Be the date that you learned that the motion to revoke bond was filed, is that
Correct.
right?
Correct.
And do you have a copy back of the test results?
They told me it would be an estimated 10-day wait, but it might come sooner.
So we're still waiting on it.
Correct.
Did you pay for the test?
Yes, sir.
How much did you pay for the test?
$275.
Okay. And was the purpose for the test to get some type of other proof about what's in your system?
It was to prove that I did not have methamphetamine in my system.
And so we don't have that.
Not yet.
This document I'm passing to you, is that a copy of the receipt
Yes, sir.
showing that you had the test? Is that right?
Correct.
Did you ask them to do a full panel, 13-panel test of you?
Yes, sir.
Okay. And we're waiting on that result.
We are.
But you can testify today under your sworn testimony that you've not taken methamphetamine.
No, sir, I have not.
Again, and I'm going to ask you this. Have you been around anyone that's used methamphetamine?
No, sir.
Okay. Where do you live?
I live at 919 Andrea Avenue, but I stay with my sister at night.
I don't know where Andrea Avenue is. Where do you live?
Bon Aqua, Tennessee.
Okay, so you live in Bon Aqua, Tennessee, and who owns that home?
My mother and father, Sonia and Santiago Cervantes.
Okay. You live with them in that house, is that right?
I do.
Now, there have been some DCS proceedings since this began, and your parents have legal custody of your children, is that right?
Correct.
And they have requested that you not sleep in that house, is that true?
That is correct.
So you can't spend the night in the house with your kids?
Correct.
According to DCS, right?
Correct.
So you sleep where?
I sleep at my oldest sister's house.
Okay, and where is that?
That is in Centerville, Tennessee, off of Grays Bend.
And what is her name?
Luana Cervantes.
And has that been approved by DCS?
Yes, sir.
And how do you get there?
My mother and my father takes me.
Okay. And then you go back to their house the next day, is that
My
right?
sister takes me back to my mom and dad's house the next morning.
Okay. How many, tell me, how many surgeries you have had since January 11th of this year?
10.
10 separate surgeries.
Correct.
And how many hospitalizations have you had?
Probably 4.
Okay, where you've stayed for extended periods of time?
Correct.
Okay. Are you currently under the treatment of a medical professional?
I am.
Okay. And how many prescription medicines are you currently taking?
Probably 6 or 7.
Did I ask you to bring me a copy of prescription medications or prescriptions you've had
You did.
for this hearing?
Yes,
And
sir.
did you bring me those today?
I did.
There's 2 documents there that have been shown to the state. Can you tell me what those are?
One of them is a full list of all medications I'm taking, and the other one is a list of controlled substances that I'm taking.
So every day, you take pills every day currently, is that right?
Correct.
All right, if we could mark those documents as the next exhibit or defense exhibit, please. Collectively, thank you. What pills do you take every day?
I take Suboxone, I take oxycodone, gabapentin, Vraylar, Wellbutrin, Xanax, and I think that's it.
And you've communicated to your probation officer the medicines that you've taken?
Yes, sir.
Okay. Now, Miss Whitney, you had some communications with Miss Whitney, is that correct?
Correct.
What's her name?
Naomi Whitney.
Naomi Whitney. And you've communicated with her by text message. She testified to that, is that right?
That's right.
Those text messages are in front of you, is that true?
That's correct.
Is that what you provided me?
This is
Are those in fact your communications with her?
correct.
I'd like to mark those, please, as the next exhibit. What was your purpose of communicating with her by text?
To find out why my bond was being revoked after she had told me I was good on my drug screens.
Okay. She's saying a very different story. She's saying you just admitted to using meth. Is that right?
That's not correct.
Okay.
I
What
never
is correct?
admitted. I went to the restroom and used the restroom while she was watching me use it. I washed my hands while she was holding the results. I dried my hands and just stood beside her while they came through, like I always have. And when they came through, I guess my medicines came up, and then she showed it to me, and we both seen the faint line, apparently. That's what we both said, we agreed upon. And I went into her office and I signed the paper like I always do, but it was not filled out yet. But I just signed the paper thinking she would just put my prescriptions on there, and I left.
Okay, so that form that's been marked as an exhibit, was it already filled out with positive, negative?
No,
Or
sir.
RX for prescription?
No, sir.
But you signed it.
I just signed it.
Did you anticipate that there was a problem with your drug screen?
Nope.
You have a lot of prescriptions you're taking, right?
Correct.
Have you even been anywhere where you can buy methamphetamine from somebody?
No, sir.
Have you been in a situation where you can obtain methamphetamine from somebody?
No, sir.
Let's talk about your GPS device, all right? Have you had problems with that device?
I've had a lot of problems out of this device.
Have you called people repeatedly about it?
I've called nationwide at least 20, 25 times over this device.
Okay, have you called me and complained about it?
I have.
Have you tried to get help to get the device fixed?
I've tried to get a new battery, I guess, but they wanted me to do the charger first to see if that would work. And the lady Destiny, she FaceTimed me and she said, that seems weird. It's not showing on my end that it's charging, but I see that it's charging on your end. And I said, well, that seems weird. She said, just step outside. I stepped outside, it connected signal, and it was fine.
Okay. What about law enforcement? Have they been to your house to check the device?
They have, yes.
How many times?
Only one time.
Okay, and what agency?
Hickman County.
Okay, and what did they do when they got there?
He knocked on the door, and I was actually charging my monitor when he knocked on the door. And he knocked on the door, and I answered the door, and he said, "Your ankle monitor's dead." And I said, "Well, that's weird. I'm charging it right now." And he got in touch with Nationwide and just told them that I was charging it, and he was watching me charge it.
Have you let it go dead?
Not on purpose.
Okay, have you tried to be anywhere that you're not supposed to be?
No, sir.
Have you, I guess, let your device go down so that you can go buy meth?
No, sir.
Are you willing to do anything the court orders about your GPS device, right?
Yes.
I mean, we got this problem where apparently your home, wherever your parents' home is, according to Ms. Harlan, there's not a good signal. We know that, right?
Correct.
And are you willing to do something about that if there is a solution to it?
Yes, I am.
So the third thing is there's been an allegation that you did not report to get your drug screens on, I think there's 3 days in the motion. Let's talk about those. August the 4th is the first day. What do you remember about that day?
August the 4th, we had just got back from Gatlinburg, and
Let me stop you there. You went to Gatlinburg with your parents,
correct.
okay? And you got approval from DCS to do that?
Yes, because my sister also went, and I stayed with her because I could not stay with the children.
Okay.
And we had just got back from Gatlinburg, and honestly, it completely blew my mind. I completely forgot about it.
Okay. So you did miss that one?
I did miss that one.
Okay. And then August the 5th, what happened?
I think that's the one that I missed, because then I went August the 7th and took the other one.
Okay.
So I
Well,
just missed one.
according to the motion that's been filed, it was August the 4th, August the 5th.
Well, I'm only supposed to go twice a week.
Okay. Did you go on August the 4th?
No,
Did you go on August the 5th?
no,
Did you go on August the 7th?
I did.
Did you go on August I don't know the dates by memory, August the 12th, I think. Did you go on August the 12th?
August the 12th, I think, is the day that they said that I failed a drug screen.
Okay. Now, the intimation has been made without any sort of expertise that you were delaying that so that you could use meth. Is that true?
No, sir. My mom was out of town last week, so it was hard for me to get a ride because I don't have a driver's license. So the
How do you
day
get to the drug screens?
my mother takes me.
Because you can't drive.
Correct.
Okay. So I'm going to reiterate. Have you used meth?
No, sir.
Have you used any illegal drug?
No, sir.
Have you purposely allowed your GPS device to run down so that the battery will die?
No, sir.
Have you missed some bi-weekly drug screens with the probation officer?
One.
And you admit missing?
I did miss it.
Okay. What is the current state of your health?
I just had a hip replacement surgery about 3, maybe 4 weeks ago. So I have an appointment to go see my ortho August the 20th,
Okay. And where's that doctor's visit at?
Skyline in Nashville.
Are you currently taking any kind of physical therapy?
My insurance doesn't cover it, so no.
But it was prescribed,
Yes,
but you can't pay for it.
correct.
All right, tender the witness.
Ms. Cervantes, you been convicted of shoplifting?
Yes.
When was that?
It's been years. Maybe 2000 and I don't know, maybe 9 years ago, maybe.
Okay, so in the last 10 years, you've been convicted of shoplifting, but you want us to believe you today, correct?
can believe me or not.
Okay. Naomi Whitney's testimony, was she just lying on the stand?
How am I supposed to know?
You've contested what she said, have you not?
I just told my truth.
Your truth. So Ms. Whitney's saying you started to act different the last few weeks. Was that true?
I mean, I've been acting the same.
Ms. Whitney testifying that you started looking over her shoulder to look very closely at the screen results when you hadn't before. Is that true?
I've always stood right beside her.
So that means what she said's not true.
I've always stood right beside her, so.
Okay. You testified about GPS. He asked if you let it die, and you said, quote, "not on purpose." So you have let it die, correct?
I mean, it has died, but it wasn't on purpose.
So there's days you charge it for 14 minutes at a time instead of the hour or 2 hours you're supposed to, correct?
There's been days I've charged it 4 to 5 hours a day.
Okay. So when their reports come up and they monitor all this, it's wrong?
That's just from here recent.
Okay. Did they notify you to step outside and do this 10-minute period to make sure it's accurate?
They do a lot.
And you heard their testimony. You continue to have many violations since then, correct?
I step outside when they ask me to.
So the violations, no reason for them?
Objection to the word violations, I don't know what that means.
The violations
Just
that
saying,
they,
rephrase your question.
the violations they testified to since you've been notified, are those true?
Same objection.
I've asked her if she's had issues with the charging of it since then, since they notified her, Your Honor.
I think he's asking her, has
think
she
it-
followed their instructions? I don't know, but
I
they're
think
not
the
violating.
objection, if I understood it, was for your characterization as a violation, and you're talking about issues that were characterized as issues.
Yes, sir.
So I've sustained it as to the phrasing of the question. So restate your question.
Yes, sir. Have you been charging it appropriately since then?
Have I been charging it inappropriately?
Appropriately since you were notified.
I charge it at least 2 to 3 hours a day.
So if they testified to issues, those wouldn't make sense, correct?
I call nationwide at least maybe 2 to 3 times a week
Okay.
because of my ankle monitor.
You testified at first with Mr. Potter that you don't leave, you don't go anywhere to get meth, but then you admitted that on August 4th and 5th, you were actually on the far end of the state, correct?
Yes, we went to Gatlinburg.
And you just completely forgot about a drug screen that you do every single Tuesday.
I did forget, it completely slipped my mind.
And then the 5th, you didn't come in at all.
Correct.
You didn't call at all.
I guess not.
You told Mr. Potter on August the 12th, I believe you said, that's the day they said I failed a drug screen, correct?
Correct.
So they'd notified you about a possible issue that day, correct?
My lawyer actually did.
So if she testified that she told you about the faint line and possible positive, is that true?
She told me she seen a faint line. We both did, and she told me I was good.
She told you you were good.
I was good to go.
Testified to all these surgeries you've had. I don't want to go into anything on January the 11th, and we're not here for that, but all these injuries, are they related to your crash that day?
They are.
So all of these surgeries, all of these appointments you need, they're related to this crash?
They are.
Did you have these issues before that day?
No, sir.
You heard testimony from Ms. Whitney that there's times that you're not positive for anything, including your medications. Is that true?
Yes, sometimes it's different.
There's times you just don't take your medications?
No, I take my medications every day, but the drug tests are different almost all the time, like every time I go.
1 second, please. Thank you. That's all I have, Your Honor.
Nothing further.
Tell me again what all you take in the way of medication.
I take Suboxone, oxycodone.
And you take those at the same time?
No, they have to be separated out. Like I'll take my oxycodone in the morning and then my Suboxone at night. And then I take Wellbutrin, Xanax, and Vraylar.
Right, and what's the purpose of the Suboxone? If you're taking oxycodone, what's the purpose of the Suboxone?
Because I didn't want to get hooked back on pain medication, after all the surgeries that I had. So I went back to get on my Suboxone, but the only reason I'm taking the oxycodone.
Tori Stedman, Toristeadman.
Where are you employed, Ms. Stedman?
Mid-Cumberland,
And what do you do for them?
probation.
Officer Stedman, do you recognize the individual seated here today with Mr. Potter?
I do.
Who is that?
Christina Cervantes.
Your Honor, if the record could reflect, she's identified the defendant.
Record will so reflect.
How do you know Ms. Cervantes?
I supervised her probation.
Would you have been her probation officer in the year 2025?
I was.
Was she on probation for a DUI?
She was.
As part of that probation, were there certain conditions that she had to meet?
Yes, there was.
Was she supposed to take drug screens?
Your Honor, I'm going to object for the record to Ms. Stedman testifying about a prior probation service. First of all, I don't know anything about that, haven't been given any knowledge about it. And at best, I'm thinking the state wants to introduce this information because they want to show that there's some propensity on the part of Ms. Cervantes to maybe violate pretrial release conditions. That's inappropriate because that would be, as Your Honor knows, 404B evidence of prior bad acts or prior character traits. So that shouldn't be admissible. I think that's where the state's going with this, to have Ms. Stedman testify that, well, I've supervised her in the past and she didn't behave in the past. I think that's where this is going.
Your Honor, the ultimate issue, I believe, from the defense argument is that she's not using methamphetamine. This is all misunderstanding. The state intends to show prior use of methamphetamine while on probation, including multiple instances of that. So I believe it's going to go ultimately towards the credibility of whether or not whether the defense's argument that this is simply a misunderstanding. I think it's completely relevant to that, Your Honor. This is not in front of a jury. This is a motion.
Your Honor, with all due respect, the facts of this case themselves are that she was using methamphetamine at the time of the wreck. I don't think that, if that's, I mean, we can take that in a light most favorable to the state that she was using methamphetamine at the time of the wreck. Not sure why it's relevant that she might have used methamphetamine years ago. In fact, I don't even know when this was. It might have been a long time ago.
Well, she's testified she was on probation, had supervised her probation in 2025. So that's the time frame that we're talking about. It does appear to me, though, Mr. Stevens, that we're talking about introducing evidence of prior bad acts on her part, which would be a 404B, but typically that is something that would have to be weighed by the court in an out-of-jury hearing. The court's going to overrule the objection, allow it in, but I'm not sure that it really has much relevance to this proceeding. I'm the one who has to make the decision about whether or not she has violated the terms and conditions of her bond. I'm going to allow the state to put on this proof, but I will make such a ruling as is necessary.
Yes, sir. Did you ever have drug screens with Ms. Cervantes?
I did.
Did she ever fail those drug screens?
She did.
When?
On 6/10/25, on 10/23/25.
6/10, is that what you said? So June 10th, 2025?
Yes.
And again, when, I'm sorry?
October 23rd.
2025?
Yes,
Did you ever have concerns about how she performed these drug screens?
I did.
And what were your concerns?
When taking her in to do a urine, it became difficult to get her to do a urine drug screen. I have a protocol when drug screening a female, and she wasn't able to do that. So we decided at that point we were going to use oral swabs with her.
Okay. Did she ever test positive for methamphetamine specifically?
She has.
Was she ever offered an opportunity to go into a treatment program for that?
Yes.
What was that?
She went into our drug program, 10 Rocks.
Okay.
So she was in there and she went to Freeman. She was in and out on a few different programs, and we did PHP with her and IOP. She had to do 270 hours of IOP prior to being released off of probation.
Was she on probation, to your knowledge, January the 11th, 2026?
She was.
With your prior knowledge of Ms. Cervantes, do you think she poses a danger to the community if she continues to use methamphetamine?
Back to relevance.
It's the issue, it's an issue in this case, Your Honor.
Edmund's opinion about that's not.
I think it also is more or less a subjective situation. I'm going to sustain the objection.
Yes, sir. That's all I have. Thank you, Ms. Stedman.
Potter? Ma'am, you have a seat. Mr. Potter needs to cross-examine you, sir.
Ms. Stedman, how are you?
Good.
Have you had any involvement with supervising any of my client's pretrial release regarding this case?
For her bond supervision,
Correct.
I've seen her a couple times.
You've seen her a couple of times, okay? And why is that? Was she reporting to you is your office in Centerville?
I'm a flex officer, so I go everywhere that I'm needed.
So were you standing in for somebody?
I go there every Thursday.
Okay, and so when you're working on Thursday, she reported to you a couple of times?
She came there twice to see me, yes.
Okay. The testimony that you just offered in response to General Stevens' questions, you were her supervising probation officer when she was on probation for a DUI. Is that right?
For a DUI and simple possession of meth,
Okay. And that was in Hickman County?
yes.
Okay. And she had pled guilty, I presume, in Hickman County General Sessions Court. Is that right?
Correct.
And so you supervised her during that time?
I
Is
did.
that right? Have you ever had someone perform a urine test that proved later to not be positive? You thought it was positive, but later you deemed it not to be positive?
I have not. She signed an admittal with her dirty drug screens.
Was there an occasion when she gave a urine test and you then sent her to have a blood test?
Yes, for a blood, Chris Ragsdale did through 10 Rocks
Well, what would be the purpose of that?
because she denied it. Would you like me to elaborate?
Well, did the blood test confirm that she was in fact positive, or did it?
I didn't get the results sent to me. Chris Ragsdale, which was the director of 10 Rocks, said that it came back negative, but we did 3 drug screens in office. 2 of them were positive, and we couldn't get enough saliva on the 3rd one.
But then you sent her for a blood test and the blood test came back negative.
Correct.
I have nothing further.
Redirect.
Since Mr. Potter asked about that, did you also send her to Freeman at some point to confirm a drug screen?
We did.
And what did Freeman say?
It was positive.
Thank you.
Anything further? Thank you, ma'am. You may step down. You can have a seat in the courtroom, or you may leave.
Your Honor, State calls Aiden Hollis.
Officer Hollis testifies. I'm going to note an objection for the record. I think Officer Hollis will not be offering any evidence to this court about my client's conduct while on pretrial release. I think he's going to testify respectfully about what investigation he conducted on the date of the accident. This was a multi-vehicle accident, and I think he's going to testify that my client had methamphetamine in her system. We'll stipulate that he's going to testify to those facts. I don't think it's necessary for him to testify about how bad the wreck was or about anything else that might. The whole purpose of that, I think, is to subjectively persuade Your Honor to revoke my client's bond. The facts of this case are not good, and we'll try those. We know they're not good, and we'll try those facts on a different date. So that's my objection.
I appreciate that, Mr. Potter, and I understand you're doing a job. I have previously stated, and I will reiterate, that this is the state's motion, and therefore the state has the right to put on the proof that they deem to be relevant. Any objection as to relevance will be considered by the court. I'm allowing the evidence to be presented first, and then I will rule on whether or not it's relevant or not, as I have in other situations. I have done this a long time, both as a lawyer and a judge, and I'm not easily persuaded just simply because somebody puts on proof that I consider to be irrelevant. I'll make this decision based upon the statutory guidelines and the applicable law and the evidence that's presented that is relevant. So overrule the objection.
Thank you.
Good morning, sir.
Good morning.
Please state your name and spell it.
Aiden Hollis, Aidan Hollis, Hollis.
Where are you employed, sir?
City of Dixon Police Department.
What is your role there?
I'm a corporal.
Corporal?
Yes, sir.
Corporal Hollis, do you recognize the individual seated here today with Mr. Potter?
Yes, sir.
Who is that?
Christina Cervantes.
Your Honor, if the record could reflect, he's identified the defendant.
All right, the record will so reflect.
Did you have an incident on January the 11th, 2026 involving Ms. Cervantes to investigate?
Yes, sir.
Where was that at?
Highway 46 and Jim Marvin Drive.
Is that in Dixon County?
Yes, sir.
What was your role that day?
I was I guess you would say, lead investigator or the reconstructionist in the crash.
Now, we're here on a motion, not a trial, so generally speaking, what happened that day based on your investigation? What did it appear had happened?
So what it appeared to have happened was Miss Cervantes was northbound on 46. She was in the slow lane, and she crossed over the fast lane, the center lane, into the opposing lanes, where she sideswiped the first car driven by Aaron Wilson, and then she...
Did Mr. Wilson have any injuries to your
Yes.
knowledge?
Yes, sir.
What was that?
Concussion.
Okay. Post-concussive syndrome, possibly?
Yes, sir.
What happened after she hit Mr. Wilson?
She hit Aiden Dwyer head on.
Okay. Anyone else involved in the accident?
So after she hit Aiden Dwyer head on, Aiden was pushed back into the southbound slow lane where he was hit again. And then after her impact with Aiden, her engine came out of her vehicle where it struck another vehicle that was going northbound.
Okay. Anyone in the car with Ms. Cervantes?
Yes, sir.
Who was that?
Alexander Linton, I believe is his last name.
How old is he?
He was 1 year old at the time, I believe almost 2.
Any injuries?
Yes, sir.
What were they?
From my knowledge, it was a fractured tibia, a fractured collarbone, and a laceration of the forehead. That was my understanding.
Would you say a severe laceration?
Oh, yes, sir.
Was a sample for blood ever collected for testing?
Yes, sir.
How did you get that?
I contacted the Horizon lab. So Ms. Cervantes was transported from the scene to Horizon, then to Skyline. Whenever she was at Horizon, they obtained her blood, and so they typically keep people's blood for a period of time. I don't know that period.
Did you get a search warrant for it?
Yes, sir.
Okay. Passed you forward a document.
Yes,
If you
sir.
could please look at that document.
Yes, sir.
Who is that addressed to in the upper left-hand corner?
Aiden Hollis.
Who is the subject of this matter?
Christina D. Cervantes.
Does it appear to show her toxicology for this matter?
Yes, sir.
Does it show methamphetamine?
Yes, sir.
What is the amount?
Greater than 2.0. I struggle with the unit of measurement. but
Possible nanograms per ml?
Yes, sir.
So greater than the cutoff?
Yes, sir. Greater than 2.0.
Your Honor, state moves to make that exhibit.
Judge,
Mr. Potter has previously objected it is irrelevant because he stipulated more or less that she was under the influence, I think, at the time. So we're going to go ahead and admit it anyway as an exhibit.
Yes, sir. Did you ever perform a search for a car?
Yes, sir.
And what did you find that was of interest?
So I found several items. Specifically, I found 2 straws. One straw was found in her center console. The other straw was found in the driver's side floorboard.
Okay. Did you send those off for testing?
Yes, sir.
Handing you a document. Who's that addressed to in the upper left-hand corner?
Aiden Hollis.
Who is the subject of this case?
Christina D. Cervantes.
Does it appear to one of those straws with white powder residue was tested?
Yes, sir.
What does it show it to have?
Methamphetamine.
And that was recovered in the car?
Yes, sir.
State moves to make the next numbered exhibit, Your Honor.
Exhibit 2.
And Judge, just for the record, obviously, this is a pretrial bond condition motion stipulating to any facts. I think the general knows that stipulating to any facts doesn't mean we're stipulating to any of those facts for purposes of trial. I think Your Honor can hear You have more liberty in these motions to let things in. That's why we're stipulating to that for purposes of this hearing. Thank
Your
you.
stipulation as to the introduction of these facts at this level does not bind you to that stipulation at trial.
Thank you.
Did you consider her actions that day a danger to the public?
Yes, sir.
Did you believe she's impaired when operating the vehicle?
Yes, sir.
That's all I have at this time. Thank you, sir.
Mr. Potter, you may cross-examine.
Officer Hollis, good morning.
Good morning, sir.
A couple of questions in follow-up to his direct questions of you. How long have you been with the Dixon Police Department?
At the time of this crash, it was 7 years, but today it's about 7.5.
Okay. Are you a certified accident reconstructionist?
Yes, sir.
Okay. And where did you get your training for that? At the
Tennessee,
separately?
Tennessee Highway Safety Office.
Is there an accident reconstruction report that's been created from this incident?
None other than the Titan crash diagram, or the Titan crash report, and then I also have some diagrams that I've put together with the measurements taken from the scene.
Have those all been produced in discovery in this case, to your knowledge?
There's a slew of evidence. I know I've turned over, I'm going this Friday to make sure I have turned everything over, but yes, sir, it will be, and if it hasn't been, it will be.
Okay, please do. Thank you.
Yes, sir.
Do you have any information that you can offer this court at all about my client's behavior during her pretrial release? Specifically, since January 11th until today, can you offer any evidence to this court about whether or not she's tested positive on a drug screen?
None other than what I've been told, no, sir.
Okay. Can you offer any information to this court, any personal information to this court about whether or not my client's GPS monitor's been working since the January the 11th, since it was installed on her?
I have no idea, sir.
Okay. And can you offer any evidence to this court at all about whether or not my client has complied with her pretrial release officer and attended her appointments?
Say that one more time. That was a long.
Do you know if she's gone to her appointments?
I'm not sure, sir.
Okay. Thank you.
Thank you, sir. You may step down. You followed this court's instructions regarding this testing.
Yes,
Tell me how it was administered,
it was administered with a urine test.
and did you observe the test or the sample being given?
Yes,
Is that the same process that you followed that you testified about earlier?
yes.
Okay. And what results were found from that test?
She was found positive for benzols, which she is prescribed. Oxy, she is prescribed. Suboxone, which she is prescribed. And then she tested positive for meth and amphetamines, which are
And
not prescribed.
How is that, how is the test reflecting that she was positive for methamphetamine?
When it is positive, there is no line in the window.
Right. So based on your experience as a probation officer and following the court's instructions regarding this bond issue, what is your opinion regarding this test, and what does it show about her use of methamphetamine, if anything?
In my opinion, it shows that she is positive for meth and amphetamines.
Fine, I'm going to allow the lawyers to question you again. So, Mr. Stevens, do you have any questions? Mr. Potter, do you have any questions?
I do, Your Honor. Ms. Whitney, so you have a copy of the actual sheet that shows lines or no lines with you?
I have the pamphlet that comes with the urine screens.
What were you showing me right before court that had the lines or no lines?
This is the urine sample.
Yeah, that's what I'm talking about.
Yes.
So you have that document. And so my understanding is you're saying that the absence of a line in one of those boxes would indicate the presence of meth?
Yes.
Okay. Did you also tell me before the court took the bench again that you would prefer for a lab to take a look at that?
Yes, we are going to send it to a lab.
Okay. And that's because of the number of medications in her system?
Yes.
Okay. And would you like that to be done? Or
Yeah.
you plan to do that?
Yes, we
Because you have
plan-
the actual urine in that there
Yes.
with you?
Yes, that's why we still have it. We are going to send it to the lab to confirm.
And that would make your opinion more certain or not?
Yes.
Okay.
Prior to these positive findings for methamphetamine on the drug screening, did she have all these other medications as well?
Yes.
So when she was prescribed these medications and taking them, from May 7th up until, I believe, August the 12th, did you have a positive for meth?
No.
Thank you.
When you send something off to a lab like has been mentioned, how long does it take to get the results back?
Can I consult with my fellow probation officer?
If you know offhand. Do you know
I
offhand?
do not know offhand how long it takes.
That's fine. All right. Anything else? Thank you, ma'am. You may step down. Mr. Stevens?
Your Honor, where there's smoke, there's fire, and in this case, I believe we have a fire. The defense objected to the testimony by multiple witnesses, but the state believes that it is imperative that Your Honor understand the history of meth, meth, and meth. Testimony was provided that previously, while on probation for DUI, and in this case, Your Honor could take judicial notice, she's charged with DUI-related offenses. In this case, I believe specifically vehicular assault by impairment as well as DUI second. When she was on probation previously for DUI, she tested positive for meth. June 2025, October 2025. She was put into a treatment program, and then while still on probation, we have this horrific wreck that you heard testimony about the injuries to numerous innocent people, as well as her one-year-old child and Aiden, a rising sophomore at MTSU. You were provided exhibits that show her blood to show, quote, greater than the cutoff or greater than 2.0 nanograms per ml of methamphetamine. So the state would argue that's greater than they can measure. Additionally, you had testimony that inside of her car is a straw with residue on it that was tested by TBI. And there's an exhibit showing methamphetamine. So she's provided an opportunity to be out on bond with certain conditions. These include doing a GPS monitoring system, where she is to ultimately charge it correctly, make sure it does not go dead. There may be some issues with whether ultimately the reception is great at her house. But the testimony was, when you charge something, it may take you some time to step out before the information is relayed to the company, but the information's correct. And since she was notified about how to step outside, we continue to see violations. She's not taking the GPS seriously. She testifies that she hasn't gone anywhere, but then remembers, oh, I was in Gatlinburg, where she doesn't go to a drug screen on August the 4th. I believe testimony may have been that she asked to reset that for the 5th, where at that time, she just completely no-shows. Doesn't appear. She decides to show up on the 7th with no update, and she passes that date. You've heard testimony, and Mr. Potter certainly questioned the knowledge, but methamphetamine is to stay in the system about 3 days. And there was a week between drug screens. Then on the 11th, she has to reset it to the 12th, where she comes in. You heard testimony, she's been acting differently the last 2 weeks. Things are not the same. She's suddenly looking over to see if something's there, wondering what the results would be. Previously, she did not. Ultimately, the results show a positive for methamphetamine. It was not sent to the lab because she signed off on it after being told at least that she had a faint line. She signed off. The state does not think the hair follicle is reliable. We have no one who has shown proof that this is the person they collected hair from. The state put up proof from the very person who collected the urine screen. There was no one here to say that was her who gave this hair sample. We don't know who gave it. We're just relying on a document saying that one was done through Workforce Essentials, but we don't know who went up there. I don't think it's reliable, regardless of what the results are. It's interesting that Mr. Potter provides all these medications. The state poses the question, then why was methamphetamine not showing up in all these other drug screens if they cause a false positive? Why is it that methamphetamine doesn't show up except for the last week, today, and August 12th? There's been no showing of prescription changes that would warrant a false positive. In fact, if there was an issue with her prescriptions causing them, the state argues we should have seen those in all the prior ones from May 7th until now. Ms. Cervantes testified with a prior conviction for shoplifting towards credibility, testified saying dramatically different things, the state argues, than the other witnesses. There's a concern here for public safety if Ms. Cervantes is out. There's rules in place. Don't use drugs. Now we have 2 drug screens that are positive. There's rules in place. Charge your battery and have a GPS monitor, and it's gone dead multiple times, which she has not contested that it's gone dead. The state has concerns for the safety of everyone else in Dixon County, frankly, Hickman County, her county, and anyone else who can come across her. She's not taking these conditions seriously. We have proof before you through testimony that she failed on the 12th and today for the 19th. Why wasn't this false positive found before today? It's because she's using meth, just like she did when she was on probation on DUI the first time, as in the wreck that we showed you, and again now. The safety to the public and the community is too great, and she's not following the conditions. Thank you.
Mr. Potter?
Respectfully, Your Honor, I'm not going to reiterate the facts of this case. I want to give you a little bit of background, though, about why we are here. So Ms. Cervantes was arrested when this case, when she was indicted, the case was presented, and she had a really high bond. And that requires a source hearing. And we were able to present proof to the district attorney's office that her bond was being made by her family, by family members, and there's no question about the illegal source of those funds. But Ms. Cervantes is in jail for several days while that's being negotiated, and she's testified that she's had 10 surgeries. So she has serious medical problems at that time for sure. And an agreement was reached with the state, well, we'll agree to the source so you don't have to wait on a hearing, but we would like her to have certain conditions. Don't drive, wear a GPS monitor, and get drug screens twice a week. And so that agreement was reached, and that is an order of this court, albeit I'll say to Your Honor that those are very onerous conditions on someone with the health problems that she has. They just are. she can't drive, so she relies upon family members to get her twice a week somewhere to be drug tested. And this GPS monitor, we're now going through this era of GPS devices. Our legislature has thought it's really wise to start imposing those devices on a whole slew of offenses. This is incidentally not one of those offenses. She's simply wearing it because we submitted to that condition. But those devices have their own problems. And we've seen that not only in this case, but in other cases. They're not always reliable. They're fallible. And we know now from Ms. Harlan's testimony that depending on where they are, sometimes they just don't get a connection. We know that law enforcement's been to her house to make sure that it's working and it's charging while they're there. They're having to call them saying it's still working. We know my client called nationwide 20 to 25 times is her testimony. According to Ms. Harlan's testimony, they've heard from her multiple times. Something's wrong with that device and/or something's wrong with where she is at with the device. But ostensibly, the purpose of the device is so that we can track where she is all of the time, and maybe to confirm she's not driving a vehicle, but that we haven't heard any testimony in this hearing about her being somewhere she's not supposed to be. So respectfully, that basis about the GPS device, I would say, is just not a basis to revoke her. I don't know how we resolve that. I don't know if we just get her refitted. They've never refitted her completely. I don't know how that works, but I would respectfully submit that that's not a reason to revoke her bond. The drug use allegations, we dispute. And we also dispute the results of this drug test that was done this afternoon. According to Ms. Whitney's testimony, she would feel more comfortable about it if a lab took a look at it. I looked at it myself, and I've been looking at those things for a long time and a lot of years, and I'm not smart enough to figure them out. It's either a line or not a line. Sometimes you barely see a line. Ms. Whitney has it, and I would submit to you that there's something there. And I just think it needs to be reviewed by someone who's qualified to take a look at it. So we dispute that. My client testified unequivocally that she has not used methamphetamine. But she's on a number of drugs. We submitted to evidence many drugs, and these urine tests that were conducted by people and by probation officers, judge, just aren't always reliable. I mean, we've had hearings in this court where someone has tested positive for a urine sample and gone directly to Horizon and tested negative in a blood sample. I submit to you that the urine tests have a lot of subjectivity built into them. And for that reason, there needs to be a better way to test. I also submit that getting tested twice a week on somebody that can't drive is pretty hard to do. And she's reported repeatedly since this happened. She's testified that she did miss a couple of visits. And we'll just rely upon the court's mercy for that. But she did miss on August the 4th, and I think there's been proof that she probably missed on August the 5th. But we are willing to certainly submit to any conditions that Your Honor imposes on her prospectively. This is not the trial. There is a presumption of innocence for Ms. Cervantes. She's here on pre-trial conditions. She's not even on probation. She's here on bond restrictions. That's the issue. Should she remain on her bond? And she made a very high financial bond to get out of court. We have a status hearing in this case. I think in October, I think that is before Judge Wallace. I believe that's right. I'm talking to the general before he retook the bench. It could be a while. And there's still some discovery things that we need to do before we have a trial in this case. Certainly, I think, according to Officer Hollis's testimony, there may even be some more accident information that's going to be produced to us in this discovery process. There may be some motions that are filed on behalf of the defense in this process. So if Your Honor revokes her bond, then she could sit in jail for a really long time. And I submit to you, for a lot of different reasons, she's not a good candidate for that. She's had 10 surgeries in 8 months. She's still under a doctor's care. She's still under a lot of medications that need to be taken. She's living with responsible adults, responsible enough at least to get a DCS and court placement of children. So her mother and father have her. Her mother's in the courtroom today. She's transporting her to a lot of things. So I think there's probably maybe 3 things Your Honor could do today. I'm just sort of thinking through what those options would be. First option would be probably to grant the state's motion and revoke her bond and put her in jail. And she'll sit there for however many months while we work through the discovery process in this case. And then the jail will have to deal with whatever health issues she's gotten, whatever medication she needs. I don't know. That's option 1. I would wish Your Honor would not do that. Option 2 would be that Your Honor get more information before making a ruling. And that would be, let's get lab results back from this test today. I would respectfully request that we be allowed to submit Workforce Essentials hair follicle test. I'm doing that at my own risk because I'm doing it because my client's telling me I'm not going to test positive for it. So, okay, go get it. And I would submit that gets submitted so Your Honor can use that as one of the factors in making the court's decision. And then the third thing that Your Honor could do is deny the state's motion. Deny the motion because there hasn't been any proof presented that there's been any substantial harm to the public that necessitates revoking this lady's bond. The proof that has been submitted, with all due respect, is attenuated at best. And so the court could deny the state's motion, leave my client under restrictions, leaving her under bond restrictions, and obviously I know and she knows that she'll have a very short lease prospectively. So I would respectfully request on her behalf that Your Honor deny the state's motion and allow us to continue to prepare her defense. Thank you.
You may.
Your Honor, just to respond to things that were stated, respectfully, when he talks about her health problems, I would submit that that's because of the January 11th accident. I would respectfully argue that that's due to her actions, and there's a special needs facility that can house her if needed. The problem with GPS, testimony was she was notified about how to fix these problems, step outside, but the problems persisted in the last week. And then finally, Mr. Potter said we dispute the drugs. We dispute the drug test. I believe it's exactly why the state put up all this proof to show that this is not an accident. This is her behavior. Thank you.
Well, this is not an easy case for the court. The situation that exists right now is that Ms. Cervantes, without going into the facts of the case, is facing a 17-count indictment in this charge. She has 2 counts of vehicular assault, count of aggravated child abuse, neglect, or endangerment of a child 8 years or younger, 2 counts of aggravated assault, reckless conduct. We have 4 counts of reckless endangerment by felony reckless endangerment by use of a vehicle, child abuse and endangerment, DUI, second offense, possession of drug paraphernalia, speeding, driving on the rest of them are traffic offenses, including a violation of the child restraint law. So there are significant charges that she is facing, and the court takes note of those facts only because that's what we're dealing with when we talk about the bond. In this particular situation, I allowed some of the proof to come in because I think it is important to set the background and for the court to hear more or less what some of the background is so that the court can make an informed decision about whether or not this is an isolated situation with Ms. Cervantes in her bond situation or if it's something more significant. And the proof has been that she was on probation at the time of that January 11th accident, that led to these charges. So when this court has to make a determination about whether or not to leave her on bond, or to modify the bond conditions, or to revoke the bond as the state requests, the court is required to follow some of the guidelines that are set forth. And 4011-118 is the statute that sets forth what the factors are that the court is to consider in setting a bond. And Mr. Potter is correct. I think if I saw correctly, it was originally was a $185,000 bond, and that there was an agreed order waiving a source hearing that was entered on April the 24th of 2026 that waived that source hearing, and it set forth those conditions, which I'll come back to. But part of that statute I just referred to says that it is the bail must be set as low as the court determines is necessary to reasonably ensure the safety of the community and the appearance of the defendant as required. So the safety of the community is a factor that the court has to consider in setting bonds and considering that. Now, when you then go to the statute that the state is relying upon for the revocation of that bond, which is 4011-141, that factor is, and they're relying upon subsection D. If after the defendant is released upon personal recognizance, an unsecured personal appearance bond, or any other bond approved by the court, the defendant violates a condition of release, comma, is charged with an offense committed during the defendant's release, comma, or engages in conduct which results in the obstruction of the orderly and expeditious progress of the trial or other proceedings, then the court may revoke and terminate the defendant's bond and order the defendant held without bail pending trial or without release during the trial. And the reason I emphasize those commas is because those are not one sentence. Those are different conditions. Violating a condition of your release on your bond is grounds for the court to revoke the bond. In this particular case, the agreed order waiving source hearing said the following conditions: notwithstanding, as a condition of the defendant's bond, the following conditions must be followed by the defendant. The defendant is required to follow the Department of Children's Services recommendations regarding the defendant's children. 2, the defendant shall be subject to drug testing not less than twice per week. 3, the defendant shall wear a GPS tracking device in order for the defendant's location to be identified if needed by law enforcement. And the defendant is prohibited from driving. Now, those were the conditions that were placed by agreement between the state and the defendant in this case. The proof before me is that she was required to take this drug testing 2 times a week, that by the proof before me, from the credible proof before me is that she tested positive for methamphetamine on August the 12th, and she's tested positive for methamphetamine today. I understand the argument to be made that these tests are not fallible, or not infallible, that there can be a problem with the testing. But we order drug testing to be done like this for a reason. And if those tests are unreliable in any way, shape, form, or fashion, then it would be appropriate for the court to simply say, we're not going to request drug testing because they're unreliable. But by and large, this was put into the agreed order that she would undergo the drug testing. So by implication, if anything, there was an implication that she submit to drug testing 2 times a week, and the results of those tests will obviously be important for the court. The fact that she missed the drug testing on August the 4th and the 5th is a violation of the conditions of her bond. The fact that she tested positive on the 12th and again today for methamphetamines is something she's tried to explain away, but it is according to what the test that the probation department uses on a regular basis. It is a positive test for methamphetamine. I am going to order that that sample be sent to the laboratory for further analysis. But at this point in time, the court must accept that test result, which was agreed to in open court by the defense and the state, that she would undergo it. She testified she would willingly undergo it. So this court is of the opinion that the results are binding upon the defendant absent of showing that that test was inaccurate. The bond requirements also requiring her to have the GPS monitoring device. The credible evidence before me from the witness from the monitoring company is that this test, that they have a means of determining when how long she's charging her device, and that it is not it is not being shown to have been tested or charged for the requisite period of time. And it went over and over and over again. Whether that is or is not accurate according to her, I have to go by the credible testimony before me, and I find the testimony of the monitoring company's representative to be more credible than Mrs. Cervantes, who obviously is testifying that she has been charging it, even though the witness for the monitoring company says that she's only charging it for 15 or 20 minutes rather than the 2 to 4 hours. Based upon the overall proof in this case, it is this court's opinion that the state has proven a basis for the revocation of her bond. However, I will revoke that bond today in order that she be remanded to custody. I will set a review of the results of the test, from the test results and from the hair follicle drug test, on the 8th day of September, my next criminal docket call. And at that point in time, I will make a determination whether to reinstate her bond or to leave her bond revoked. I want to see what the results are. That's the judgment of the court in this case. This matter needs to obviously be moving towards a resolution at some point, but I'm of the opinion right now that if it's set in front of Judge Wallace on his docket, then you all can deal with him about that. In any event, there was one other thing I will I'll state about the testimony in this case. I have real issues with the fact that I have no issue with the fact that she's been through some significant surgeries. However they occurred, her injuries, she's having to get treatment for them. And she'll have to have treatment for them and follow-up treatment, while she's in jail. And I consider that in making this determination. But the fact of the matter is, her testimony that the drugs that she is taking is a combination of oxycodone and Suboxone seems to me to be completely inconsistent with the purposes of each of those medications. She's under a lot of medications. That may be necessary, but I think that's something she needs to get checked out. In any event, the court has ruled that the bond hearing, that the state has proven grounds for a revocation of the bond. The bond is revoked pending a review by this court on September the 8th. We stand adjourned.
Your Honor,
A father came to court asking for uninterrupted FaceTime calls with his 10-year-old son. He claimed the mother was interfering with their conversations and preventing the child from speaking privately. The mother's side disputed those claims but agreed that a fixed schedule could help. The judge decided that FaceTime was the next best thing to being face-to-face and ordered calls every Tuesday and Thursday at 7 p.m. The father would have 15 minutes to initiate each call, while the child would be allowed privacy during the conversation. The judge...
You've not seen her since that August 12th date?
Correct,
She hasn't reported
correct,
or been drug tested?
correct.
You have the necessary equipment to drug test her today if I decide to do that?
Yes, I do have a drug screen in my vehicle.